Thank you, Algo sir. I think you have wonderfully invited everybody and welcomed everybody. So, without further ado, I uh, welcome today's speaker, Advocate Renoy Vincent. He's no stranger to us, but still, I will briefly cover his credentials. So, Advocate Renoy did his schooling in Rajagiri Secondary School in Nakulam. Thereafter, he went on to do his BA LLB in Honours from Newells. He started his practice in the Honorable High Court of Kerala and the District Court and other various tribunal forums in the state from 2017. Then he had a brief stint in the Karnataka High Court as well. So he's been all around the place, including the Supreme Court in his tenure. And during this time, he's moreover, more than handling his own matters, he is well equippedly briefed various senior counsels, senior advocates. So, and he specializes in white collar crimes, civil and commercial matters, and including criminal litigation. So, his forte would be in the field of writ jurisdiction, and he will be covering the topic laws on writs. So, without further ado, right now, Advocate Renoy Vincent is practicing before the Honorable High Court primarily, and he's a senior associate in Shah Associates at our club, and he's also my colleague. So, without further ado, I welcome today's speaker, Advocate Renoy Vincent. Over to you, Renoy.
Thank you, Rango sir and Advocate Chelson, for that warm welcome and introduction. I thank the organizers for giving me this opportunity. Like Elango sir had mentioned in his opening remarks, speak on this platform. So before I start, I am conscious of the fact that it is not just the lawyers who are here present for this function, for this session. There are various other people from different fields who are taking a part in this session. So my endeavor in today's webinar would be try to explain the topic of writ jurisdiction, the law of writs, in a basic, simple manner. So without wasting any time, let us jump right into the topic, which is the law of writs. So now let us first try to understand what a writ is. Because every day, either from the newspapers or from the TV channels, we always hear about writ petitions, അല്ലെങ്കിൽ writ ഹർജികൾ. ഇന്ന് ഒരാൾ ഹൈക്കോർട്ടിൽ റിട്ട് ഹർജിയുമായി അപ്രോച്ച് ചെയ്തു, അല്ലെങ്കിൽ സുപ്രീം കോർട്ടിൽ റിട്ട് ഹർജിയുമായി അപ്രോച്ച് ചെയ്തു. അപ്പൊ നമ്മൾ എപ്പോഴും എന്താണ് ഈ റിട്ട് എന്നുള്ളതാണ് ആദ്യം നമ്മൾ അറിയേണ്ടത്. സോ ടു ഗിവ് എ വെരി സിമ്പിൾ ഡെഫിനിഷൻ, I will say that writ is an order or a direction that is issued by the court to a person or an authority to do something or not to do something for the purpose of enforcing his right. So this is the definition. So I would like to explain what exactly a writ is by breaking this definition into three parts. First, writ is an order or a direction issued by the court. We'll stop it there. So an order or a direction issued by the court. നമുക്കെല്ലാവർക്കും അറിയാം, there are various types of courts. We have the magistrates court, the municipal court, sessions court, district court, etc. But as far as a writ is concerned, it can only be issued by two courts, which is the High Court in each state under Article 226 and also the Supreme Court under Article 32. So these are the two courts which can issue the writ. Now coming to the second part of the definition. Writ is an order or a direction that is issued by the High Court or the Supreme Court to a person or an authority. So now there can be a confusion as to whom the writ can be issued. Who is a person or an authority? ഇപ്പോൾ നമുക്കറിയാം ഇപ്പോൾ അഡ്വക്കേറ്റ് ചെൽസൺ is a person. So he is a private person. Now whether a writ could be issued against a private person, the answer would be no. Because the person or an authority in a writ jurisdiction would be a person or an authority which would satisfy the definition of a state under Article 12. Now, the most important question is, what is a state under Article 12? Now, a state under Article 12, Namkarayam in layman terms, state means state of Kerala, state of Tamil Nadu, state of Karnataka, etc. പക്ഷേ Article 12 state is something much more than that. It is not just the state of Kerala or state of Tamil Nadu, or it is just the central government or the union government. It is much beyond that. It would include an officer of the state government. For example, it would include a village officer, an RDO. It would include the officer of a central government, who can be a customs officer or an EPF commissioner, etc. It can include a local authority. A local authority in Varyanangi could be a municipality or a panchayat. And most importantly, it could include other authorities who has the state government or the central government has a deep and pervasive control over. If suppose a government controlled company, life insurance corporation, that is a state. If a state government controlled corporation, if a supply co, that it's a state. So it is not the state that we understand in layman terms, which is a state under Article 12. It is much broader than that. So a writ petition would lie only against a person or an authority which would satisfy the definition of state as given under Article 12. So that is the first thing that you have to keep in mind. So like I mentioned earlier, the litmus test to find out whether an authority organization filed a writ petition under Article 32 before the Honorable Supreme Court seeking an issuance of a writ against BCCI. Now, we all know that BCCI performs certain public functions. It regulates the sports of cricket in our country. It selects the national team which has to represent at the international stage. So there is some sort of a public function attached to it. But the Supreme Court said that just because of the fact that there is a public function attached to it, that does not automatically make a body a state under Article 12. Because BCCI is a body which is not either financially or functionally or administratively controlled by the government. So in that case, in 2005, 4 SCC 649, those who are noting down the citation, 2005 4 SCC 649, which is the C Telefilms Limited versus Union of India. The Honorable Supreme Court held that BCCI is not a state. And even recently, our Kerala High Court, one of the questions that was to be determined by the Honorable Kerala High Court in R.N. Joseph versus the District Collector, President of the Ernakulam Rifle Club Association, was that whether the Ernakulam Rifle Club Association is a state or not. And the contention of the petitioner therein is that it is a state because the District Collector, which is an officer of the state government, is the ex officio president of that particular association. Again, the High Court said that nothing doing, it is not a state. It is only a society that has been registered under the relevant laws. It would not qualify the definition of state as given under Article 12. So Article 12, which gives the definition of state, is extremely crucial to understand the concept of writ jurisdiction, because it is only against a body which qualifies the definition of state, a writ petition would be amenable. Now, this is an article which has gone constant evolution, because in 1951, if I give an example, the Air India came into force by way of an enactment of a central act. So at that time, it was fully owned by the government. Now in 2022, Tata has completely acquired Air India. So an Air India, which would have been amenable to writ jurisdiction in 1960s, 1970s, will not be amenable to writ jurisdiction at the present. So because of the changes that have been brought to our country, both politically and economically, for instance, the 1991 economic reforms that were brought in, by the then Finance Minister Dr. Manmohan Singh, which included liberalization, privatization, and globalization. A lot of changes have happened. So, because of this, the concept of state under Article 12 is always evolving and it is always changing. So, one thing every lawyer and every other person should understand is that a writ would be maintainable only against a state. So, that is the second part of the definition. So, writ is an order or a direction that is issued by the Supreme Court or the High Court to a person or an authority which satisfies the definition of a state under Article 12. Now, this direction would be to a state instrumentality to do an act. There comes the third point, or not to do an act for the enforcement of a right. So, to do an act or not to do an act, I'm sure that everyone will understand that. But what does it mean for the enforcement of right? This is the crucial difference between Article 32 and Article 226. Because both Article 32 and Article 226, the Supreme Court and the High Court has the power to exercise writ jurisdiction. പക്ഷെ ഇതിന്റെ ഡിഫറൻസ് എന്ന് പറയുകയാണെങ്കിൽ ഈ എൻഫോഴ്സ്മെന്റ് ഓഫ് റൈറ്റില് കാരണം ആർട്ടിക്കിൾ 32 സുപ്രീം കോർട്ടില് ഇറ്റ് ക്യാൻ only be issued for the enforcement of a fundamental right. So what is a fundamental right? Fundamental rights are those rights that are guaranteed under part 3 of our constitution. We have article 14, article 19, article 21, which we all know of, right to life and personal liberty, etc. But as far as Article 226 of the Kerala High Court or the High Court is concerned, it is issued not only for the enforcement of a fundamental right, it is for the enforcement of any right. For example, take the example of right to property. We know that right to property is a right which is guaranteed to a person under Article 300A of the Constitution. It is a constitutional right. It is no longer a fundamental right. So, for the enforcement of a right to property, which is a constitutional right, a person will have to approach the High Court and not the Supreme Court because the latter is not a fundamental right. So, these are the three major components which would constitute what we call as writ. So, writ is an order or a direction which is issued by the Supreme Court or the High Court to a person or an authority which qualifies the definition of state to do something or not to do something for the enforcement of the right of that person. In the case of Supreme Court, it would be the fundamental right. In the case of High Court, it could be any right. So, if we are coming to the first principles, we would say that writ is a public law remedy. We say that writ is a public law remedy because it is against a state. Now, to people, those who don't understand the difference between a public law and a private law, is that a public law is the law which regulates an individual by the society. It concerns an individual and a society. For example, the constitutional law, the administrative law, taxation, municipal laws. These are all examples of public laws. Whereas private law is a law that governs the relationship between two individuals. For example, contract, law of succession, torts, property laws, etc. For that, if we have to enforce our private law, we'll have to approach the civil court because that would include the exercise of taking evidence and everything. So, writ is essentially a public law remedy. That is why it is always said that under writ jurisdiction, we do not go into disputed questions of fact. That is also one of the basic principles of writ jurisdiction. Because if there is disputed questions of fact, then that would invariably include the exercise of taking evidence, which can only be done by trial courts. It cannot be done by the High Court under Article 226. So these are the basic features, basic principles one must understand of what a writ actually is. Now, coming to the second part of my presentation, which is to give a basic historical background as to how the system of writ came into India. So, writ has its origin in England. We have all heard about Magna Carta. Magna Carta is a social document that was executed in the year 1215. it gave certain right to individuals. Now, for that individuals to enforce that right, the power of writ was given to the court and the king there for the purpose for that individual to enforce that right. So this was brought into India by the British by way of the Regulating Act 1773, and this was brought in the Government of India Act 1935, and subsequently it was brought into our constitution, which we all know in the form of Article 32 and 226. So one important thing that I would request all the participants to bear in mind is that in England as well as in India, writ is basically prerogative. It is prerogative in nature. Now, എന്താണ് ഈ prerogative എന്ന് പറയുകയാണെങ്കിൽ? Prerogative means basically it means that it is discretionary in nature. It always depends on the discretion of the High Court judge or the Supreme Court judge whether to issue the writ or not. Now, of course, this discretion cannot be exercised whimsically. There are settled legal principles on which a High Court judge or a Supreme Court judge should issue a writ. So that is why on a lighter vein, നമ്മുടെ ഇവിടെ എപ്പോഴും ഒരു ക്ലയന്റ് വരുവാണെങ്കിൽ ഐ എം ഷുവർ that is applicable to all the lawyers who are practicing in the High Court. So when we hear the client talking about his case, depending on the subject matter, we always look at the roster to see which judge will be hearing that matter. If we suppose a tax matter, we'll be looking at that judge who will be hearing the tax matter as per the roster. For municipality, we will be doing that. That is because not every judge would use the exercise of discretion uniformly. You can understand that there might be judges who are liberal judges. There might be judges who are not that liberal and a bit of conservative judges. So depending on the judge who will be hearing a writ petition, it goes a long way in deciding what the fate of that writ petition would be. I'm not saying anything in a bad light, because of course there are settled legal positions on which a judge should exercise its jurisdiction while deciding a writ petition. But there is a great deal of importance to discretion which can be exercised by a judge while entertaining a writ petition. That is why it is said that a writ petition that is filed by a person against a state or a state instrumentality for the enforcement of fundamental right is always maintainable. A writ petition is always maintainable if as long as it is against the state and it is for the enforcement of a right. But it need not be always entertainable. So there is a difference between maintainability and entertainability. So the example which I would like to give you is that suppose a person has been issued with a demolition notice by the secretary. Say suppose Kalamassery municipality secretary issues a demolition notice to a person under section 406 of the Municipality Act, directing that person to demolish his building. Appo namukku venengi parayam that person is aggrieved by that particular notice. That notice has the potential of infringing his right to life. കാരണം അയാൾ താമസിക്കുന്ന വീടായിരിക്കും അത് പൊളിക്കാൻ വേണ്ടി വരും. And the secretary of a municipality would answer the definition of a state under Article 12. So now my question to the audience would be, in such a scenario, would the writ petition against that particular demolition notice would be maintainable? Can I get any answers from any of the audience? Okay. So I hope that everyone knows the answer, but they're a bit shy to tell what the answer is. So in that case, normally a writ petition would not be maintainable. That is because under section 509 of the Municipality Act, that person has a right to file an appeal before the LSGT tribunal, which is a specialized tribunal constituted under the Municipality Act. So there is a alternate remedy which that person could avail. Of course, the situation would be different if the demolition notice is issued without hearing the petitioner or by serving a provisional order. Then, of course, there is a option for that person to directly approach the Honorable High Court. But in a normal situation, when a demolition notice is issued, the remedy of that person would always lie before the appellate tribunal, even though it satisfies all the three conditions that I set out earlier, which I'm not repeating once again. Another example that I can give you is that suppose an assessment order is passed by the state tax officer under the GST laws. Here also, there is a person who is aggrieved by assessment order passed by the state tax officer who satisfies the definition of state. Now, this order has the potential of infringing his right to carry on his trade and profession, which is a fundamental right under Article 19. Again, whether a writ petition would be maintainable, of course, it would be maintainable, but it will never be entertained by the High Court because there is an appellate remedy under the GST laws, which is to file an appeal before the appellate authority, which is the Deputy Commissioner Appeals, etc. So that is the subtle difference everyone has to understand. A writ petition can invariably always be maintainable, but it need not be entertainable because that would depend on the discretion of the judge who will be hearing that matter. So two judgments everyone can refer on this point is one, Prod Air Products. One is Manohari R versus the Deputy Tahsildar, which is writ appeal number 1143 of 2024. And the other one is Prod Air Products India Private Limited versus State of Kerala. The citation is 2023 3 KLT 234. So these are the two judgments which deals with this concept of maintainability and entertainability of a writ petition. Now we have understood, I hope we have understood what a writ is. We have understood the historical evolution of writ. Now we have understood that writ can always be maintainable, but it need not be entertainable. Now let us go to the main part of our discussion, which is the various types of writ which can be issued by the High Court under Article 226 and the Supreme Court under Article 32. So there are 5 types of writs which could be issued by the constitutional courts. One is mandamus, the second one is certiorari, third one is habeas corpus, fourth one is quo warranto, and fifth one is prohibition. So now I'll be explaining what each writ is, what each of these 5 writs are. So the first writ is mandamus. So I'll say that mandamus is one of the most commonly used writs that we can see in a writ petition. So for a High Court to exercise the power of issuance of mandamus, it should satisfy 4 basic requirements. The first requirement is that the person who's seeking the issuance of writ of mandamus should have a legal right. 2, the person against whom the petitioner is seeking for the issuance of writ of mandamus should of course satisfy the definition of state under Article 12. That will be a constant in all these various types of writ which could be issued by the High Court or the Supreme Court. Now the third requirement is that respondent against whom we are seeking the issuance of a writ of mandamus should have a corresponding public duty to discharge in favor of the person who is seeking the issuance of mandamus. So I'll once again come back and I'll explain everything with the help of an example. And the fourth requirement is that the person who is seeking the issuance of mandamus ought to have made a demand, and there should have been a refusal on the part of that authority. Then only he has the locus, he has the right to approach the High Court or the Supreme Court for the issuance of mandamus. That is the first principle. If he makes if he directly straight away comes before the High Court without making a demand, then such a writ petition would be premature. Now, I can give you an example so that which would satisfy all these four conditions. നമുക്കെല്ലാവർക്കും എല്ലാവരും ഒരു ലൈഫിൽ ഒരു പോയിന്റിൽ ഫേസ് ചെയ്തേക്കുന്ന ഒരു ഇഷ്യൂ ആയിരിക്കും. നമ്മുടെ ഭൂമി, നമ്മുടെ വീട് നിൽക്കുന്ന ഭൂമിയിലെ നമ്മുടെ അതിന്റെ കരമടച്ച റെസീപ്റ്റ് നോക്കുമ്പോൾ നമുക്ക് അതിനകത്ത് നിലം എന്ന് കാണും, അല്ലെങ്കിൽ നഞ്ച എന്ന് കാണും. അപ്പൊ അതിനകത്ത് ദീസ് ആർ വേരിയസ് ടൈപ്സ് ഓഫ് നേച്ചേഴ്സ് ഓഫ് പ്രോപ്പർട്ടി ദാറ്റ് ഇസ് ദെയർ അണ്ടർ ദി കേരള കൺസർവേഷൻ ഓഫ് പാഡി ലാൻഡ് ആൻഡ് വെറ്റ്ലാൻഡ് ആക്ട്. അപ്പോൾ നമ്മുടെ പ്രോപ്പർട്ടിയിൽ നമുക്കൊരു വീട് വെക്കാനുണ്ടാവും, പക്ഷെ അത് നിലവല്ല, അതൊരു പാഡി ലാൻഡ് അല്ല. പക്ഷെ റവന്യൂ റെക്കോർഡ്സിൽ അത് പാഡി ലാൻഡ് ആയിരിക്കും, അല്ലെങ്കിൽ ലോക്കൽ ലെവൽ മോണിറ്ററിംഗ് കമ്മിറ്റി പ്രിപ്പയർ ചെയ്തേക്കുന്ന ഡേറ്റാ ബാങ്കിൽ അതിനെ നിലം എന്നായിരിക്കും കാണിക്കുന്നത്. അപ്പൊ അങ്ങനത്തെ ഒരു പ്രോപ്പർട്ടിയിൽ നമ്മളൊരു ബിൽഡിംഗ് പെർമിറ്റ് ആപ്ലിക്കേഷൻ കൊടുക്കുവാണെങ്കിൽ it would be rejected by the secretary, saying that unless and until you regularize, you change the nature of that property, we won't permit you to allow the building permit application. So adinatha you have a legal right. You know that it is not a nilam, it is not a paddy land which is in your property. So you have a legal right to get that property, to get the nature of that property changed or converted from nilam to puredam. So you satisfy the first requirement. Now, under the provisions of the Kerala Conservation of Paddy Land and Wetland Act, if the property is included in the data ban, which is shown as nilam, then you have to submit a form called Form 5 before the RDO. Now, the RDO has to consider a decision, has to take a decision by taking into consideration the report of the agricultural officer, etc. Now, because of the large number of applications and cases that will be pending before this particular RDO, this RDO, even after receipt of this application, will not be taking any decision. So, there is a legal right that you have. The RDO is the authority who has to consider that application, which is Form 5 that you have submitted. And RDO has a reciprocal obligation to consider and pass orders in that Form 5 application. Of course, you don't have a legal right to get that Form 5 application allowed. Your legal right is to have that Form 5 application considered by the revenue divisional officer. So that is the legal right, and there is a reciprocal obligation. You made that application and the RDO is not taking a decision. So in such a circumstance, what is the remedy that is available to that person? The remedy is to seek an issuance of writ of mandamus. Is a writ of mandamus, so we will say that the writ petition is filed seeking the issuance of a writ of mandamus to respondent number 1 or 2 or 3, depending on which the RDO, or now as per the recent amendment, the authorized officer can be the deputy collector as well, RDO or the authorized officer, to consider and pass orders in that particular Form 5 application that I have submitted in a time-bound manner. So this is a classic example where a writ of mandamus would be maintainable. I'll give you another example. Another example is where, suppose I have a property and my neighbor is growing trees in a way that it comes to my property and which is causing great inconvenience and hardship to the person who wants to file the case. So, under the municipal laws, under the Kerala Municipality Act, the secretary is bound to abate such nuisances. He has the power to direct that landowner to cut down the trees so as to mitigate the hardship and inconvenience that is caused to this particular landowner. So, suppose you file a complaint before the secretary, but unfortunately, the person against whom I filed the complaint is a politically influential person. So because of that, the secretary is not taking any action. Now, this is an action which he is statutorily bound to take. So even in that circumstances, you can file a writ of mandamus, directing the secretary to take up and pass orders in my complaint after affording me an opportunity of hearing within a time-bound manner. So that is also an example where a writ of mandamus would be maintainable. Now I will give you an example where a writ of mandamus would not be maintainable. So suppose if I am the owner of a bus, I have a route permit that has been issued by the RTA. Now it is issued for a term of, say, suppose 1 year. So after when it is going to expire, I file an application for renewal. But this time I file an application before the village officer. See, in this case, I have a legal right for my application of renewal to be considered. But does the village officer has the reciprocal obligation to consider my application for renewal of a regular permit or a travel permit? The answer is no, because it is for the regional transport authority under the Motor Vehicles Act to consider the application. So, since there is no reciprocal obligation in this case, the writ petition of mandamus against that village officer in the particular facts and case will not be maintainable. So, that is a broad overview of writ of mandamus. Now, let us come to the second writ, which is also very commonly used, which is the writ of certiorari. Now, at the outset, it has to be said that it is through the writ of certiorari the High Court and the Supreme Court exercises the power of judicial review. If suppose an order is passed by the officer or an authority which satisfies the definition of state under Article 12, and if that order if is illegal or irrational, or if it suffers from procedural impropriety, or if it does not pass the muster on the principles of doctrine of proportionality, then you have a right to approach the Honorable High Court under Article 226 seeking for the issuance of a writ of certiorari. Now I will explain to you as to which are the legal principles on which a writ of certiorari can be issued. Like I said earlier, if the order is illegal, irrational, procedurally improper, or if it does not pass the muster of law on the touchstone of doctrine of principles of proportionality, then that order can be quashed by the High Court. So the first ground, which is illegality. So tomorrow, suppose imagine the scenario where the state government has issued a government order stating that from tomorrow, every state government employee has to pay 10% of their income as income tax. If such a government order is passed, that order can certainly be struck aside or quashed by the Honorable High Court by issuance of writ of certiorari, because as per our constitutional scheme under 7th schedule, only the union government has the power to levy income tax on its employees or citizens. It cannot be done by the state government. So unless and until there is a law which permits the state government to impose income tax, the government order that will be passed in this particular hypothetical situation cannot withstand the scrutiny of law. So it can be quashed by the High Court or the Supreme Court by issuing a writ of certiorari on the ground of illegality. So that is the first example. Now let us come to irrationality. Irrationality, when we hear about irrationality, one test which always comes to our mind is the Wednesbury unreasonable test, which says that if an authority, after going through all the relevant documents and after eschewing all irrelevant documents, come to a conclusion which no prudent ordinary person would ever arrive at. If such an unreasonable, irrational decision is taken, then such a decision can be struck down on the principles of irrationality. One example that I can give you is that suppose if tomorrow, say Delhi government or Kerala government issues a rule stating that only persons with say 6 feet height will be allowed to be admitted in higher secondary school. If such an order is passed, they might have the power to impose qualifications or conditions in order to regulate the admissions. But if they come up with such an absurd condition, then it can be struck down by the High Court or the Supreme Court under writ jurisdiction on the principle of irrationality. So that is the example of irrationality. Now, the third ground on which the High Court can exercise the power of judicial review by issuing a writ of certiorari is procedural impropriety. Now, procedural impropriety would mean this: it is nothing but principles of natural justice, adherence to principles of natural justice. Suppose in this example that I'm going to give, a trader or a businessman who is a registered dealer under the GST laws. One fine day, he is summoned by the state intelligence officer or the tax officer to make an inquiry about his taxable turnover. In that meeting, it is said that he has suppressed his taxable turnover, and there is a meeting that has taken place. And suppose on the very next day, the state tax officer, without conducting any inquiry, without issuing a notice, and without affording an opportunity of hearing to that particular dealer or that businessman, passes an assessment order mulcting a huge demand, fastening a huge liability on him, then even though there is an alternate remedy under the GST laws, which I had mentioned earlier, which is to file an appeal before the appellate authority, who will be the Deputy Commissioner of Appeals, etc., he can straight away approach the Honorable High Court, because this is an order that has been passed in violation of principles of natural justice. This is an order that has been passed without hearing that particular businessman. So, in such situations, the High Court would not relegate that party to approach the alternate remedy, the statutory remedy that is available to him. The High Court will certainly, or the Supreme Court in certain cases, would certainly entertain such writ petitions. So that is the example of procedural impropriety. Now, the third ground is the fourth ground on which nowadays the Constitutional Court exercises its power of judicial review, and which is now very commonly used, is the principles of doctrine of proportionality. Now, the simple example that I can give you is that this: suppose in a university, a student is caught talking to another friend of her or his in a classroom, and the teacher scolds her. Teacher refers this matter to the vice chancellor, and the vice chancellor in turns issues an order stating that she is debarred from the university and she would not be allowed to write exams for the next 3 academic years. And the misconduct that she has done, or the indiscipline that she has committed, is that she spoke to her classmate while the lecture was going on. Now, in such a situation, whether such a excessive, a disproportionate punishment would sustain the scrutiny of law is the question. Here also the answer would be in the negative, because this decision that has been made by the Vice Chancellor can be struck down by the High Court or the Supreme Court under the writ jurisdiction on the principles of doctrine of proportionality. So these are the basic 4 grounds on which the High Court and the Supreme Court exercise its power of judicial review, and through which they issue the writ of certiorari. So, writ of certiorari is nothing but a challenge against an order that has been passed by a person or an authority which satisfy the definition of Article 12 of the Constitution. Now, the third writ, which is perhaps the most fundamental and precious writ which is there, because this is a writ that concerns with the personal liberty of an individual, which is the writ of habeas corpus. Now, writ of habeas corpus, the name I'm sure everyone is familiar with. Habeas corpus means produce the body. If suppose a person is illegally detained under the custody of another individual, then of course that any person who wants that person to be released can approach the High Court or the Supreme Court for the issuance of writ of habeas corpus. Now, traditionally, this is a writ that was used in detention matters. So, when we talk about detention matters, we mean that there are various detention laws that are there. Detention laws such as COFE POSA, National Security Act, CAPA, etc. So, under these detention laws, you all will be aware that even if a person who has not committed the crime, in order to prevent that person from committing a crime, that person can be detained. So, if a person is detained under the preventive detention laws, there are certain procedural safeguards that has to be followed by the detaining authority. For example, if a person is detained, that person has to be issued with a detention order. He should be supplied with the complete list of documents and other materials that have led to that have led the detaining authority to pass that order. Then there must be an opportunity of a representation, the right to file a representation that has to be given to that detainee. So if there is any procedural irregularity that has happened, then the detention would get vitiated. For that, he or she or any person, of course, it won't be the detainee who would be filing the writ petition because he is under the custody. So suppose if a person is detained, his father, his mother, or his wife can, as a next friend, file a writ petition seeking for the issuance of writ of habeas corpus, saying that this person is under illegal detention because of the fact that the procedural safeguards that are in place while a detention order is passed has not been fulfilled or adhered to. So, this is a classic example where a writ of habeas corpus can be issued by the High Court or the Supreme Court. Now, present days now, where instances where we see writ of habeas corpus that is being issued is mainly in matrimonial cases. So, suppose if a man wants to marry a woman who's, of course, above the age of 18, but her parents are not permitting her to meet him, and she has been detained by her parents. In that case, the man has the right to file a writ petition seeking the issuance of writ of habeas corpus, directing the respondents to ensure that the detainee, in this question, the girl who he wants to marry, to be produced before the court. When such a writ petition is filed, the court will direct the SHO or the district police chief, who are usually arrayed as respondents in such a writ petition, to ensure that that particular girl is produced before the court. On second or third day, that girl will be produced, and on that date, the court will be asking her the question: whether are you under illegal detention of your parents? If she answers in the affirmative, then she would be set at liberty. She would be directed that she can't be confined by her parents, and which would help her to go with that man. But if she tells that she is not within any confines or she is not under the detention of anyone, and she is acting on her free will and volition, then of course that writ petition would be dismissed. So this is perhaps the most precious and fundamental writ which is there. That is because it concerns the personal liberty of an individual, which is considered to be sacrosanct. Now, let's come to the fourth writ, which is writ of quo warranto. So, quo warranto means on what authority? So, there are three requirements that has to be met by a person when a person seeks the issuance of a writ of quo warranto. Now, writ of quo warranto can only be issued against a person, that is the first requirement, who holds a substantive public office. So this is the first requirement. That person should be holding a substantive public office. The second condition is that that particular substantive public office has prescribed certain qualifications for that person to hold that office. For example, under Article 58 of our Constitution, it deals with the the appointment of a citizen as the president of our country. Now, there are certain conditions. So, there is no doubt that the office of the president is a substantive public office. Now, the conditions that are there is that he or she must be a citizen of India, he or she must be having at least 35 years old, and he or she must be qualified to be a member of parliament, Lok Sabha. So these are the conditions. So suppose tomorrow, if a person gets appointed to the post of the president who is having an age of 30 years, now that person will not satisfy the eligibility, the qualification that is required for a person to be appointed to the post of a president. Now, against that person, this is where the remedy, the issue of writ of quo warranto would lie, because it could be issued against that person to show on what authority that he is holding the post. And if he can't satisfy to the court that he is not having 35 years of old, then the High Court would issue a writ of quo warranto directing him to remove from his office. So this is an example where a writ of quo warranto can be used. Now, another example that I would like to give you is that suppose in MG University or Cochin University or Kerala University, any university for that matter, a person is appointed as the vice chancellor. So when they invite notification calling for applications to the post of vice chancellor, they will prescribe the qualifications which are there in the university statutes. So suppose, for the sake of example, let us say that there is a qualification which would say that that particular individual should have at least 10 paper publications in his name. Now, a person has been appointed. Now, a few years later, after his appointment, an individual comes to know that particular gentleman does not have 10 paper publications to his name, to his credit. He only has 8 paper publications. In such a situation, a writ of quo warranto would be maintainable against that particular vice chancellor. So this is a writ which is slightly different from other writs, because this is a writ where the question of locus standi or the question of laches cannot be brought in. So suppose when I say locus standi or laches, first I'll explain what laches is. So I'll say that I had earlier mentioned that a writ is always maintainable, but it need not be entertainable. Suppose even if there is even if there is no statutory remedy, suppose I got an assessment or I got an order that has been passed by a state government, by a state under Article 12 today, and 10 years later, I approach the High Court challenging that order. Now, even if that writ petition is maintainable and it merits interference because of the illegality which is there in that order, still the High Court can turn down from interfering that matter, because on the issue of laches, because I took 10 years to approach the High Court, so I've been a fence sitter. So on that ground, it could be turned down by the High Court. And also locus standi. Here, any third party, any individual can approach the High Court or the Supreme Court for the issuance of writ of quo warranto, because that individual, what he is basically doing is that he is doing the role of a whistleblower. He is only bringing an illegality that is there against a person who is holding a substantive public office to the attention of the court to merit interference. So the strict rules of locus standi and laches is not applicable to writ of quo warranto. That is also another point that you have to bear in mind. Now, coming to the last writ which is there, which is the writ of prohibition. Now, writ of prohibition, I'll say that it is not commonly seen used, but I've heard that I've been told that it is a very effective tool which could be used if it is exercised properly. Now, writ of prohibition basically means that if suppose a tribunal or a quasi-judicial authority is going to do something or is proceeding in a manner which is in excess of jurisdiction or which is without jurisdiction. So a tribunal or a quasi-judicial authority is proceeding in a manner which it does not have the jurisdiction or which is far beyond its jurisdiction, then in such a case, the High Court or the Supreme Court can issue a writ of prohibition prohibiting that particular tribunal or that quasi-judicial authority from further proceeding in that matter. For example, I can give you the example of an income tax appellate tribunal. Income Tax Appellate Tribunal is a specialized tribunal that has been formed under the Income Tax Act to deal with matters pertaining to and ancillary to Income Tax Act. So if a person has suffered an income tax assessment order, it would be passed by the commissioner, then there is appeal to the Commissioner of Appeals. Then from there, his remedy would be to approach the Income Tax Appellate Tribunal. Suppose the Income Tax Appellate Tribunal, while entertaining a matter, they go into the question of whether a fraud has been committed, whether this particular individual has cheated the department, whether he has committed a crime, then those are areas in which the income tax appellate tribunal does not have the expertise to go into. Because the question of whether a person has committed the offense of cheating or has done a criminal offense, that would lie within the realm of an investigating officer, a prosecution, a police officer. So when an income tax appellate tribunal goes into that question, certainly that person against whom proceedings is issued, he or she has the right to approach to invoke the writ jurisdiction, seeking the issuance of writ of prohibition. So writ of prohibition is a writ which is not commonly that seen, but it can be used effectively if properly used. So these are the five types of writ which is there. Then there is also not just Article 226, then there is Article 227 also. But I don't have the time to deal with Article 227 because it is a supervisory jurisdiction that is being exercised by the High Court, which is a different topic altogether. So my endeavor was to just confine my presentation to the various types of writ which is there. For example, what is a writ, its historical evolution, and the different types of writ which is there. So one thing that I would like to tell you in the context of Article 226 and 227 is that if suppose there is a question where a civil court or a district court passes an order against a person, directing that person to suppose if it is in a rent control petition, the rent controller, which is a civil court, a municipal court, passes an order of eviction directing the defendant or the respondent in that particular rent control petition to vacate that property. Now, this is also a case where there is a violation of his rights guaranteed under the Constitution. So the question is this: whether a writ would be maintainable against an order passed by a trial court or the subordinate court. The answer would be negative. This has been settled by the Honorable High Court in Radhesham matter, which I would give the citation. So the citation is, right now I don't have the citation, but I will give you the citation. It is a 2015 Supreme Court judgment where it has been held that writ would not lie against the trial court. This is a topic this is an area which I should have mentioned under the heading of writ of certiorari. So with this, I hope you understand what a writ is. So writ is basically an order or a direction that is being issued by a court. We now know that it is either the High Court or the Supreme Court. It is issued to a person or an authority which satisfies the definition of a state, and that authority or a person is directed to do something or not to do something, and that is being done for the enforcement of the right of that individual. If it is for the fundamental right, then Article 32, the Supreme Court can be approached. And in Article 226, it's not just the fundamental right, any other right can be invoked for the writ jurisdiction to be exercised. Then after that, we have understood what a writ of mandamus is. Writ of mandamus is essentially a direction that is given to an authority who is having a legal duty back to the person who is seeking that right. Then there is a writ of certiorari, which is the writ through which the principle of judicial review is being exercised by the High Court and the Supreme Court. Then there is a writ of habeas corpus, where it means to produce the body of a person who is under illegal detention. Then there is a writ of quo warranto, which is a writ can be issued against a person who's holding a substantive public office and who does not meet the requirements, the qualifications that he has to fulfill to occupy that particular position. And then there is a writ of prohibition where quasi judicial authority or a tribunal proceeds in a manner in which there is no jurisdiction or they have acted in excess of jurisdiction. So I hope you have understood the basics of writ jurisdiction and law of writs. So with this, I conclude my presentation, and I'll be happy to take questions. I know that it is already it is already past 9:30. So if there are any questions, I will be more than happy to take it. So that is the end of the presentation. Thank you.
Thanks a lot, Renoy, explaining writs, all the 5 writs in a fantastic manner. That too from the history, how writ has come, what is Magna Carta. From there you started and you have explained nicely. We all are happier. Of course, you could explain that needs some more time. Thanking you. Any